So this is another judgment, Supreme Court judgment, and this judgment is pertains to a criminal case which was lodged under 498, that is domestic violence case. Now, uh, before I go ahead and give you some of the aspects of 498. Let me first tell you a couple of things. Number one, if you go to uh, a trial court, or if you are practicing in lower court, or if you think of practicing in trial court, you should know one thing, that is maybe somewhere between 80 to 90% of the advocates, they feed and thrive on cases that are directly or indirectly pertains to 498. And I mean, the numbers are huge actually. And most of these 498A cases, they get disposed of. uh, Hardly you would find cases where maybe the person or the accused, alleged accused, has been convicted. And one of the reasons for it is the in a way you can say that they don't file a complaint when it comes to 498A. Rather, they lodge their emotion. And if you read the FIR, you will find it mostly encapsulates their emotion, their the kind of resentment that they fostered within them, rather than talking about what exactly happened or how things happened. Rather than talking about the facts, they talk about mostly it's a reflection of their emotion. So this is again, as I said, this is a judgment that comes out of an a complaint that was launched against this petitioner or appellants in this case under 498. There were two cases actually which were lodged against this uh, appellants. One was under 498 IPC, and the other one was under Dowry Prohibition Act. So these are the two cases which were lodged against this uh, appellant. And luckily, or maybe thankfully, he was able to get all the charges quashed from Supreme Court. But prior to this, appellant tried to raise the same before trial court. He was unsuccessful. Then it went to High Court. High Court did not quash the proceeding. Rather, what High Court did is that sort of granted a pre-arrest bail. High Court directed that arrest is not necessary, or custodial interrogation is not necessary. However, the petitioner would cooperate with the investigation. But aggrieved by that decision, uh, the appellant here challenged that High Court decision, came to Supreme Court, and he was able to get those charges set aside or quashed, all the judgments. Now, the major reason, as I was saying, that 498 complaint mostly is a reflection of uh, wife's emotion, rather than narrating the facts and the circumstances. So let's start some of the So here you can see respondent 2 lodged a complaint against the respondent 2 would be the wife accused, and this is from here I think I can start talking about the issues with this 498. So the moment the wife decides to uh, out of vindictiveness or maybe some to take revenge or vengeance, what they would do is they would implicate not only the accused or the husband, but rather she will tend to implicate the entire family, even though maybe some of them are not staying there. In this case as well, the petitioner or the appellant and the wife, they were living separately, and the in-laws, they were separately, and there are some other in-laws who were living completely in a separate, but somehow in the FIR she included all of them. Now, if I scroll down here, I'm just taking you through the important. I'm not getting into the allegation, what the allegation that wife brought, or the different allegations that the husband brought on the wife, because those are very common element when you think of 498. So you will always have complain and then counter complain. So and this case is also no exception, so I'm not going to get into that. However, uh, on page 7, the Supreme Court or Apex Court did notice this phenomena, that case and counter case, or complaint or counter complaint. This is called counter blast. So this is something that always weakens your case. It doesn't matter which side you are on, whether you are for the husband or the wife, as long as this particular pattern is there. So if someone comes to you, or if you are even a victim, uh, and if this particular it becomes, it gives, or rather it produces a lot of suspicion in the actual merit of the case, because it seems like they were just trying to get even, or one party or the other was just trying to get even with the other party. No specific allegation. Now, this is the highlight of this particular case, and also, as I said, most of the 498 cases, like many a times when I'm there in the courtroom, I would listen to many anticipatory bail application filed against 498 uh, complaint, and the judge would always say that the complaint is general and omnibus in nature, hence we are inclined to grant in anticipated bail, custodial interrogation, so on and so forth. So, and this particular phenomena, this nature of allegation or complaint, without going into the specific events or specific moments that gave rise to those allegations, they are missing. Mostly it talks about their they try to put down as many uh, individuals that they can implicate in that case, or mostly going about general allegation like drinking, uh, assaulting, humiliating, uh, a few other things that can also be brought. But the thing is, they are often very generic in nature, until and unless the victim can show the specifics. So again, this is something, a learning lesson even for an advocate as well. So if you are helping your client to lodge an FIR under 498, a few things I would recommend not to do. Number one, don't go by the story that is being narrated by the victim, because victim might get carried away with the emotion, but you need to kind of understand how the court procedure works. So instead of implicating all of them, you better go for only the accused, not to implicate the whole family members. Even though I understand that directly or indirectly they can also be implicated, or they might also be responsible in many ways. But if you implicate them, it becomes very generic in nature, and that is what uh, most of the, I would say, spouse they do when they tend to lodge complaint under 498. So this is something I would request advocates to avoid. Be very specific, talk about specific uh, specific allegation. Like, you can think of a particular day when certain events happen, then you go on you incorporate those details, maybe date wise or month wise, year wise. So that creates a momentum that can help you to proceed with your allegation, instead of writing something that are very generic. If I go to page 7, page 15, here also you can see apex code observed, and it states, a bare perusal of the FIR shows that the allegation made by the respondent number two, which is the wife, are vague and omnibus, other than claiming that appellant number one harassed such and such. Respondent number two not provided any specific detail, described any particular instance of harassment, something that I was talking about. So better you target specific events that are majorly responsible for this whole allegation, not to go for the entire don't create an entire story that seems often vague or non-specific. uh, and again it continues the same. You can see uh, yeah, here you can see court again observed that respondent number two in the FIR seemed to be motivated by a desire for retribution. As I said, that whenever your allegation follows the allegation of the other party, this counterblast phenomena is often, it jeopardizes your case tremendously, because court is going to notice it. And often indeed it is the case that subsequent or counter allegations or cases are retributive steps, or just to get even with the other side. And this is not a good practice, but anyway, that's a different aspect altogether. So I think that pretty much at the end, if I just scroll down here, you would see there are a lot of case studies that this Apex Code referred, or previous cases Supreme Court referred to come to a conclusion. But either way, these are uh, the core, I would say, observations basis on which this particular judgment or the verdict was given. And uh, you can see charge sheet, whatever which was filed, they all were quashed at the end. So whenever, if you are an advocate or if you are a victim and thinking of lodging a complaint under 498, it is always advised that be very careful with your FIR, not to lodge a very generic or vague uh, complaint against your spouse. And definitely don't go by your emotional impulse outburst while implicating the whole family of your spouse. Better uh, you go for specific events upon which you are relying, or specific moments, the date, the time. So that's how you think, you try and build your case, which will also help you. I mean, this will also help you to sustain your case in the high court and even in the apex court, because uh, there will be specific, uh, let's say, allegations or investigations to conduct to find out uh, the truth, or to get to the merit. But if you make a complaint, or if you lodge a complaint uh, that is very generic in nature, where you just say, I was harassed, I was mentally, physically assaulted, I was not given respect, or my husband drinks, uh, gambles, asking for money, and all those things, they really don't stand in the case, because often from the experience we know that those things are not factually accurate. The truth is something else, and uh, judges are quite used to this sort of stories. So it certainly won't help your case either. So be very specific, uh, and uh, you know uh, talk about mostly the events that uh, led to this dispute and all this, and try not to implicate the whole family. That's it.